When someone is arrested, whether they're held in jail or let go and given a court date, they will have to make a first appearance before the court. This means that you will be required to appear before a judge and enter a plea of guilty or not guilty. This is stressful, intimidating, and depending on what you're being accused of, very scary. Over the next few minutes, I'm going to outline everything about making a first appearance that you need to know before you step foot inside that courtroom. I'm Sean P. Keenan, a North Carolina criminal defense attorney, and I practice in Jones, Lenoir, and Greene counties. One of the most common questions we get from people being charged with a crime is along the lines of what to do when making a first appearance. In this video, I'm going to guide you through what happens and what you need to know so you don't make any mistakes. Remember that anything you say or do can be used against you, so make it through the entirety of this video so you don't miss any important details. Point 1. What is the purpose of a first appearance? A first appearance is when you are officially informed of the charges against you. Courts are required to do this because it's your constitutional right. The number one thing you want as a defendant is to come out of the first appearance knowing what crimes are alleged against you and how long you could be incarcerated for them, if at all. Point 2. What to do, what not to do. There are a few things you want to make sure you don't do at a first appearance. Do not talk about your case. Do not try to discuss what happened with the judge or anybody in the courtroom. Do not represent yourself. There's an old saying, anyone who represents themselves has a fool for a client. The judge will ask you if you want a court-appointed attorney, to hire your own attorney, or represent yourself. If you don't know what you want to do, I recommend getting a court-appointed attorney if you're eligible. You can always hire someone, but if you waive counsel, you may not be able to get a court-appointed attorney down the road. Point 3. What to do next. Here are a few tips of advice on things that you should expect to do next. 1. Get in touch with your attorney. Don't wait for them to call you. 2. If you're in custody, do not talk to anyone in the jail about your case. Those conversations are not protected, and any inmate can get a deal if they testify against you in court. Do not talk about your case or anything illegal on the phone with your family and friends. Odds are, jail personnel are listening in on your phone calls. Talk to your attorney and be completely open and candid with them. Any conversation with your attorney from within inside the jail is not going to be listened to, and that's the law. Attorney-client privilege exists. And don't worry about your attorney judging you because of what you tell them. Chances are they've seen it all before. I create free videos like this so I can help people further understand how to navigate the criminal justice system and not get lost in the mess that it is. If you or someone you know has been charged with a crime, contact our office. Schedule a consult, and I'll spend valuable time with you going through your situation and letting you know what you can do free of charge. Your case is my mission. Get a Marine to fight for you.